obviously here to talk about the Heartland Greenway carbon capture pipeline. Hopefully what I'm going to be able to share with you guys today is some things that you need to know, or that we would hope that you would know as you kind of try to navigate through this process. And I am with Sever Storey law firm. I'll get to that. Let's start with why are we here? One of the big things that we preach in our practice is you guys as landowners only have one chance to try to navigate this process. It can be a complicated process. It can be an emotional process. There's a lot of things that are going to happen. And we want to make sure that you guys have the information, the most information that you can to navigate that process successfully. So we really preach, hopefully being a resource, helping people get informed, that kind of thing as we present information to people. So who are we? We are Sever Storey Law Firm. My name is George Paget. I am one of the attorneys with Sever Storey Law Firm, and we are a firm. I apologize. I'm getting ahead of myself. I'm going to tell you a little bit about what we do. I'm going to tell you about how I think we can help folks that, like you guys, that find yourselves in the position you find yourself in. I'm going to talk a little bit about the pipeline, the project that brings us all together, mostly what you guys should expect as part of that process. Also talk a little bit about, forgive me. I'll talk a little bit about, I know there's a fight going on with projects like this. There almost always is. So we'll talk a little bit about that. We'll talk about Eminent Domain, the big boogeyman, Eminent Domain. We'll talk about what that looks like, some of the things you guys want to know about that. And then also we'll talk a little bit about pipelines generally and how what kind of impacts this kind of thing might have on your property if and when, but particularly if it does in fact make its way to being a tangible thing that is on your property. So the Sever Storey, like I mentioned earlier, we're a law firm. We do eminent domain. Eminent domain is the only thing that we do, and we only do it for landowners. So we have a really focused, almost niche practice that focuses on people that are in your exact position. So after doing that for about 15 years now, we feel like we've got a pretty good handle on, what folks should expect, how the processes typically play out, what things to look for, what things to know, all of that good stuff. We've sort of carved out, we started in the Midwest predominantly. We've sort of carved out a more national focus here. So major pipeline projects like this, major large scale utility projects are something that we do pretty much all across the country. We do what I would call like the more standard eminent domain road projects, things like that as well. Here, just a second. Okay. I apologize, guys. So we do that typical eminent domain stuff as well. But that's, the national, as far as being national, we focus most of our national attention on this type of utility work that we're here to talk about today. So one of the biggest things we want to be today, and hopefully moving forward, but as we move forward with the folks that may or may not move forward with us, these relationships will change. For right now, we want to be a resource. I know that's the kind of thing that folks in my position say a lot, and it may not always resonate with everyone. Of course, there's always this underlying motive as a person who's in business that I would like to work with some of you folks as well. But that I realize and recognize it's unrealistic for me to expect to work with everybody that I come into contact with as part of these projects and throughout my career, right? So I want to be a resource for everyone first and foremost. And then if those relationships morph into attorney-client or further than this, then that's wonderful. But I really hope that whoever I've interacted with, and I think as a firm, whoever we've interacted with, has at least left that interaction in a better spot, more informed, and better able to navigate this thing, even if they choose to do that on their own or with someone else. So that kind of goes along with the idea of you folks arming yourself with as much information as you can get, and then being prepared for what's to come, making, as I mentioned before, the most informed decision that you can make. So how can we help you? Well, I mentioned earlier that there's potential, there's a group, there are groups where we're not involved, so I'm not intimately aware of exactly what's going on, but we're aware of challenges to the pipeline. If those challenges to the pipeline end up being unsuccessful, then landowners may end up facing eminent domain. And eminent domain, as I mentioned before, is sort of where we, sort of our bread and butter. That's where we have our expertise and can help folks. So what we're predominantly doing for folks in the eminent domain context is ensuring that they receive just compensation, which is a concept that essentially means being paid fairly. It can get a lot more granular than that, but in the broadest sense, it means being paid fairly for what's being taken from you as part of this process. And even if it doesn't get all the way to eminent domain, even if there's negotiation and agreement, I mean, that still obviously entails being paid fairly and receiving that just compensation one way or the other. There's two sides to this particular coin that are not always present in every single eminent domain context, and that is that the easement document in any other contract, whether it's a option agreement or a side letter agreement or an access grant, all of those things are contractual in nature, and the negotiation of those contracts is important. For some folks, it's going to be more important than the compensation. For others, it's going to be less important. But because there's always going to be that different, level of importance for different folks, we kind of view those two things as almost equal. That you want to make sure that you not only get paid fairly, but that you also don't sign a contract that you and your children and their children are going to regret being signed for years and years to come. So ultimately, like I said earlier, even though everyone's not going to work with us, we definitely want to be a source of information and assist folks and help. So hopefully the rest of this presentation will do just that. Every once in a while, I'm going to pop out of here just to make sure that I'm not missing any questions or anything like that from folks that that may be asking them. So when you see me pop out of screen share, that's what I'm doing. All right, so let's get back in here. So the Heartland Greenway carbon capture pipeline. As I mentioned, I'm going to touch on it. I hope this isn't going to be too upsetting for folks, but I don't really want to focus too much on the actual pipeline because not only am I not an expert in pipelines generally, I'm certainly not an expert in this pipeline or this project. Obviously, we've done some research. We know what's going on. We know some, parts of this puzzle, but we are not necessarily here to talk about, the merits of the project or any of that stuff. I want to focus more on the information that we can provide, and if, as I mentioned before, if folks want to get back in touch with us and have some more of those conversations surrounding the pipeline and different other ideas and concepts, that's perfectly fine but for today, we're just going to kind of focus on what it is. And so, that's essentially a very, very large scale pipeline project that is intended to help trap carbon. And so, pipeline projects, I think, generally are not viewed as very environmentally friendly. And while this one may not be either, ultimately, it's at least billed as one that's supposed to help the environment. From what we know, which is not always everything by any means, one of the benefits from our perspective of doing these meetings and getting in front of people and talking to folks is that we don't always know exactly where the process is, exactly what people on the ground are hearing. exactly, what the company is doing behind closed doors. We don't have access to a lot of that information until somebody brings it to us. So what we know is that the process is still in the relatively early stages. I think that they're shooting to be building this thing within the next couple of years. That is fine for them to have goals. We've been down this road enough times to know that those project timelines are very fluid. Things can change, things do change. And there's no guarantee that if they tell you we're going to be making offers on X date, we're going to be surveying on X date, we're going to be constructing on X date, that any of that is actually going to be coming to fruition. So as far as we know, still pretty early. I think our intel that we have so far is that there are property owners that are receiving at least pseudo offers. If your situation isn't that, I don't think that's any reason for alarm. Those kind of things are very fluid, and it could be county to county or state to state. There's lots of different factors that will play into whether you are at the exact same place as another person on the pipeline in terms of the process. But as a whole, this is a project that's going to impact thousands of landowners in 5 states. This is a very large project. And so when there's that many folks that might need help, you're going to find firms like ours out here trying to help those folks. So I have a slide just about the fight, predominantly because we've learned to be a little bit, I think considerate is the right word, when we talk about eminent domain and some of the later steps, some of the things that are to come, because a lot of people that are involved with this project as on the landowner side are still going to be very much at this stage involved in the fight. And we understand with this project specifically that there's some fairly organized opposition, which frankly, and I hope that it comes off as sincere because it is wonderful. We are at Sever Storey we've kind of adopted, especially with these pipeline projects, an attitude of, we hope we're not needed. If at the end of the day, nobody ever has to call us to say, help us negotiate this easement and compensation, that's wonderful because, first and foremost, the folks on the ground whose property is going to be affected are the most important. And if the desire is for this project not to come through, then we hope it doesn't. As I mentioned, though, we're not involved in that opposition, at least at this point in time. And I want to make sure the messaging is clear that nothing that I'm saying today is intended to indicate that we think that opposition will be unsuccessful. We want to make sure that everyone who we get in front of understands we are genuinely on your side. If there's a way that we can help, we'd love to hear from you about what you think that might be. But even though we're talking about some of the steps that we haven't gotten to yet, that doesn't mean that we are presupposing them as a foregone conclusion, or that we don't have, a lot of respect for the folks that are out there fighting the good fight. We've just, found that the earlier you get any kind of information in front of folks, the better, right? I think that's what it really boils down to, is wanting people to have the full armory to attack the issue, rather than for folks to be sitting around thinking, well, the only thing we can do is fight this thing, and then if that's unsuccessful, everyone's in a state of total and utter despair. They don't know that folks like us are out here, and they don't know how to move forward. So, in a nutshell, we're aware of the opposition. We're not involved, but we want to be respectful of that opposition and make sure that folks don't think that we are trying to, circumvent or discredit or any type of other descriptor you might put there as far as it relates to that opposition. So next, I want to talk about eminent domain generally. I'm going to pop back out here real quickly. Okay. Eminent domain is a concept, but its root is in the actual United States Constitution. In the Fifth Amendment, there's a takings clause that essentially says that the government will not take private property without payment of just compensation. So that's where that just compensation term comes from as well. And I don't like to go as absolute as to say that every state has also it in their constitution, because I don't believe that's true, but it is very frequently also codified in either state constitutions or in law in individual states as well, because the federal government is obviously not the only entity that exercises eminent domain. You'll also, some folks are probably wondering why a private company has the right to exercise eminent domain, because especially with utility work, it's not always or frequently is actually almost never the actual government that is doing the taking. But there's and this is sort of a longstanding thing, that certain entities that provide public services like utilities are able to become quasi-governmental agencies for purposes of eminent domain when they have a project that they are proposing that is for a public good, which is that next line you see. That the idea, the real crux of eminent domain is the government's power to take land from a private person and to use it for a public purpose. So those private and public are important, because if it's private to private, that is typically not something that eminent domain allows. And frequently publicly owned land is exempt from eminent domain, not in every single case, but usually it has to flow that way, private to public. And so what a public purpose is, I think reasonable people, if we're just sort of thinking about what we would think of as a public purpose, could probably disagree. What I will tell you is that generally anything that serves as infrastructure, public infrastructure particularly, is going to typically qualify. So roads, railroads, electric transmission lines, pipelines that transport virtually anything that is used by people, water, oil, natural gas is actually the biggest one that we see eminent domain used for most frequently when it comes to pipelines. And then also in this particular case, we're talking about, different CO2 and things like that. So I think that conversation about, is this a public purpose, is an important one. I'm not necessarily here to weigh in on it, as I said, or as I kind of alluded to earlier, but I think that when we talk about that battle or that fight that's going on to try to stop the pipeline, I think that that's something that is relevant there, because there's not necessarily guarantee that the power of eminent domain is going to be granted to these folks. So that's just something to think about, and hopefully kind of to help inform people's understandings of what's going on and what decisions are actually being made when it comes down to whether or not these companies or this company is going to be able to use eminent domain. I'm not going to get into the nitty-gritty of the process today because we're really far away from that. But I do just want folks to know basically how it works. If they are granted the power to use eminent domain, and if they decide to exercise it, it's going to look something like this. They're going to make an offer to you for your land. They're going to say, here's exactly where our easement needs to be. Here's where our temporary easement needs to be, if there's going to be a temporary easement. Here is the acreage, and every element essentially of what they're going to take from you and what that will look like. They will also offer you some amount of money for that easement. Most folks are not going to be happy, particularly folks that are inclined to come to meetings like this are not going to be happy with what that offer entails. So there is a negotiation, typically a negotiation period that will precede a lawsuit, which is the eventual end game, if the parties are not able to come together. Some of the things that we see, questions we get most often about that process is, are they required to negotiate? And the answer is not really. They're required to make a good faith offer, and then they certainly can negotiate if they would like to, but they are not required to entertain your position and to try to, they're not required to try to work with you to meet you where you are. Although, typically, just like anything else, there's always going to be some amount of wiggle room for them where they would do a little bit for you to get you to sign on the dotted line. But no, they're not necessarily under any obligation to try to bridge that gap. If they make that first offer and they say that's it, that doesn't necessarily violate the law in any way. Once you get to that lawsuit, you're usually litigating in state court. So it'll usually be in your county where your property is located. And it's a fairly standard litigation. At the end of the day, the idea is that there's two questions to be answered. Do they have a right to take? And then also, what's it worth? And so once you've sorted out, do they have a right to take? You move on to what's it worth? And then it just becomes a battle of evidence, essentially. Who's got the better evidence that indicates that their theory of value is correct? And if you can't come to an agreement, you end up in trial. So I mentioned this before, but it's again, you see it here again because it's important. As a landowner, what you're entitled to through that legal process is just compensation. I mentioned that it essentially means being paid fairly, but to get a little bit more specific, you are supposed to be put into the position that you were in before the project, but with a monetary form of compensation creating that scenario, right? So it's a very land focused process. If your land was worth $1 million before and they take it all, then you would be entitled to $1 million. Here, we don't have a total taking ever, but we also don't even have a total taking of all the rights on the land that they're going to occupy, because the very nature of an easement is that you are only relinquishing a portion of the rights that you have to the property that you subject to that easement. So it gets kind of complicated in terms of what is just compensation. There's a lot of room for both disingenuous and genuine disagreement and discussion about what and constitutes just compensation. Whether an easement is worth 50% of the fee simple, which is fee simple is another way of saying the total bundle of sticks, the entirety of the rights that you have to a piece of land, or whether it's worth 90%. I might be getting a little bit ahead of myself because I've got a slide about how these things impact the property, but that's what we're talking about when you get to that point, is what should you be paid based on what your land is worth and what kind of impacts that this pipeline is going to have on your land. Both physical and also like from what we would call like a utility perspective, like potential development, things like that. So here comes that pipeline impacts portion of the slideshow. All right, so a pipeline, depending on the type of property you have, depending on what you use your property for, depending on where the pipeline, there's all kinds of factors that are going to come into how significant these things are going to be. And this is only a small list of the potential impacts, because every property is different, every situation is different, and every landowner is going to have different concerns as it relates to what the introduction of a pipeline easement is going to do to their property. I imagine, because this is typically how this goes, that most of the property owners affected by this are going to have agricultural land. So I focused some of these things that I've put here on the slide on the agricultural nature of land. But I do want to say there's definitely a lot of other things that could come into play when it comes to a pipeline. This is just a few examples to kind of give you guys an idea of the things that we're looking at and the things that you guys should be considering when you talk about and think about what this might do to your property. So the biggest thing is there's a strip of land that they will be impacting physically, where the easement will cover that piece of land, and the easement will forever, most often, encumber that strip of land. So the value of that land is almost always number one. You start there. Is that land worth $2,000 an acre, 5,000, 10,000, 15, or 50? Right. So there's always a spectrum. I know that in certain parts of the country, land values are insanely high, and in other parts of the country, they're not. In certain counties, you're going to see pretty significant differences. We've been involved with a pretty large project in Kansas, and I'm seeing large differences in the average price per acre in certain counties compared to other counties. So we're pretty familiar with that variability, but that's issue number one. What's that land worth? And then you get into part two, which is a lot less concrete, but sometimes more important because of the sort of lasting impact, and especially because for most of these anyway, the impact is actually not even on the easement ground, but on the rest of the ground that you own as well. So some of the really typical ones are crop loss, farming inefficiencies. When it comes to like crop loss specifically, I'm sure folks have probably Googled and been exposed to photos of land that's had a pipeline put in where the restoration wasn't done very well. And then there are long-term impacts where crops essentially don't grow for years. And they can have, 10% yields a decade later, or still have 10%, 20% loss of yield a decade later because the ground just never recovers without significant intervention, which is difficult to do because there's a pipeline under there. So there's only so much that you can do as part of the agreement that you've signed with the company to make things better. So that's a big one. When we talk about farming inefficiencies, it's not quite as common with pipelines because they are underground, but you see those a lot with electric transmission lines, which are above ground, but they still are present with pipelines because again, it goes back to restoration, it goes back to the quality of the workmanship, but sometimes these can create sinkholes and change the way water flows across property and cause different kinds of problems like that affect the way that farmers are able to utilize that property forever, essentially. Another big one is development restrictions. Probably the biggest burden or the biggest loss of rights is probably the better way to put it from a landowner's perspective when something like this occurs is that in perpetuity, or as long as that easement exists, you will never be able to build anything permanent on it. No homes, no structures. Otherwise, you can't even plant trees. You can't, pave over it completely. You will typically have the ability to put like a perpendicular road across or something like that if you need to, but you can't just make it a parking lot. So there's a lot of ways that can hinder development potential in the future. Now that's only going to come into play for certain properties, I understand, but that's an important factor for certain properties. Then you also have some people's homes will be close to this pipeline, and so there's lots of studies out there that say that if you are within a certain distance from a project like this, your home is actually devalued as a result. Folks are not going to want to live next door to a pipeline easement. And so stigma, you'll see in all caps down there, that's something that we talk about a lot, because whether any of these specific issues impacts your property or whether there are different issues or issues we've never even encountered before, the reality is that for most folks, there's going to be some type of stigma attached with purchasing a property, particularly if there's any residential element to it that has a pipeline easement on it because of perceived danger, perceived inconvenience. the possibility that the pipeline folks might be back at some point, digging around, doing all kinds of things, messing with your enjoyment of your own property. And so even if, you don't get down into the nitty gritty of the specific reasons why this is going to have an impact on your property value, there's going to be probably at the very least some amount of stigma devaluation at play due to the fact that this easement now exists on a property where it did not exist before. So again, that's just a kind of a very first grade, rudimentary level discussion of some of the impacts of pipeline easements, but they're real and they are impactful for folks that get affected by these projects. And so those are some of the things you should be thinking about, considering as you move forward. But yeah, that's definitely, those discussions are probably a little bit premature at the moment. They may not be, but I suspect that they probably are. But either way, like I said, a big part of this is getting information in front of folks and letting you use that information however it is that you'd like to use it. So we certainly wanted to let you know that is, those are some of the major things that we're looking at and considering when we talk about this. I mentioned before that, for today, we're just wanting to get information in front of folks and then potentially have some more individualized conversations if that's desirable. In the pre-COVID age, we used to get out on the ground and we still do, but we used to start out on the ground in front of people in a hotel conference room kind of setting, doing these meetings. And maybe you wouldn't believe how sidetracked we would get with property specific questions about regulations and laws and different things that not necessarily everybody that was present would have been interested in or desired to be informed about. So for the way we've kind of structured this from the post-COVID era is try to get this information in front of folks and then encourage people who want to have more conversation or additional conversations to reach out to us. I've put my phone number and my email right there. I think you've also got you have a phone number on the postcard that you received. Our website, landownerattorneys.com, you can always go to. There's ways to contact us on there. There's phone numbers, emails, all that good stuff. So if there is anything that you would want to know that I haven't covered today, or if you've got any, specific questions about your property or your experience, or even if you just want somebody to kind of give you a little bit more information about, the process in general, that's what we're here for. A big part of our practice and the investment that I make in folks like you before your clients are those conversations, right? I can't expect somebody to simply hear my name and hire me, right? So we're happy to do that. We're not going to request anything in return. So you don't have to be worried about getting a bill for my time or anything like that. So genuinely, if there's anything that anyone would like to communicate with us about, just reach out and we'll be happy to answer those questions and have those conversations and help you guys through the process. There are other attorneys in the firm. So if for whatever reason you can't get a hold of me or I'm not available for a period of time, we can certainly make sure if you reach out to either to me or to the firm more generally that we can get you with someone who can help you. And then I think that's about all that I have prepared. So I'm going to drop out of this screen share situation here. If folks want to get in touch with me, like I said, I'm available whenever. You can call me this afternoon if you'd like. But I'm going to wrap it up there. I certainly appreciate everybody's time. Thank you all for making it today and for being willing to hear us out. And hopefully you guys have learned something and feel like you're a little bit better equipped than you were when we got here. So I'm going to go ahead and end the meeting. Thank you guys again. And I hope to hear from oh, wait, it looks like I got a Q&A. All right, good question, Ken. And something that I probably should have included in the presentation, but I didn't want to get, like I said, too down into the weeds. But The question is, how do we get paid? So the way that we typically get paid is on a contingency fee basis. So we have a very heavily contingency practice, which means that when you receive an offer, that forms a baseline for your compensation. We take a 33% contingency fee on the value that we can add for you. So we don't work on an hourly arrangement very often at all. It is available. We will do it. But for a lot of our clients, it doesn't make sense. It's not a good gamble, if you want to put it that way. And what I mean by that is, unless you have a huge offer and you're supremely confident that the amount of compensation that you should be receiving far exceeds the offer that you've been given, and you're resource heavy and can afford to pay attorneys, thousands, tens of thousands of dollars over the life of a case, it's not always a good risk proposition to sign up on an hourly basis. We have found that the contingency fee structure works the best for the folks that we work with in our practice. And I think that there's not only for us and for not only for like the hourly versus contingency fee side of things, but also I think attorneys and clients can have a somewhat there can be a little bit of tension in that relationship when it's on an hourly basis, because if you're paying me and you're literally writing checks and you're seeing that money go out of your account, and I'm not delivering results for you in the timeline and in the manner in which you would like for that to happen, that can create a lot of tension. But the contingency fee is good because I don't get paid anything until it's over. And I only get paid based on the value I was able to provide for you. And it aligns our goals, right? So one of the things that I think is probably the most tenuous in a relationship on an hourly billing, schedule, especially in a situation like this, is, am I really trying as hard as I can to get you to the end of the road as quickly as possible? And am I really trying to get you as much as possible? Because if you're paying me no matter what, my incentive structure is really more shaded towards, and we'd like to think that people will overcome these incentive structures and just do the right thing. But I think the reality is, and we've probably all, can agree on this, that there are just folks who won't do that, right? So with the contingency fee, we're on the same side. If I come to you and say, I think this is the settlement point, you can trust me, at least a lot more than you can trust me in the alternative scenario. And conversely, probably more so, if I tell you this isn't the point to stop, you can trust me because I'm not going to make any more money by just keeping this thing going, right? So that's the long answer. The short answer is 33% contingency based on how much additional compensation we can recover for you. And so if I were anticipating like a couple of follow-up questions to that question, I would anticipate, what if someone wanted to sign up before they had an offer? That's totally fine. We basically wait for the offer, and then we fill in that blank on the contract that says how much we get paid once we have that information. Or I'm sorry, not how much we get paid, where our contract starts once we have that information. So that's always a big one that we get. And a second major follow-up is does the contingency include everything? And the answer to that question is that it includes everything that has to do with me. The way that we've kind of structured things in our practice is the only costs that that our clients bear, that we do not bear, are expert related costs. So what the chief way that manifests in our practice is in appraising fees. So if we were to, not every case is going to justify getting an appraisal, require getting an appraisal, but some will. And so in those cases, the appraisal fee, whatever that appraiser, that third-party professional appraiser charges to appraise your property, the taking, and give you an opinion of just compensation, that is going to be the landowner's responsibility to foot that bill. There's a couple reasons for that, chiefly ethical. If I'm being honest, there's ethical considerations all over the place for attorneys, but in this particular context, there's ethical considerations for attorneys funding litigation. There are rules in place that basically say we're not allowed to fund litigation. Like, we cannot take all costs away from our clients. We can't take all skin out of the game, because if we do so, then as attorneys, we're of course inclined to be litigious, and things never settle and things never get done. So expert related fees are the only carve out. And for 99% of folks, the only expert related fee is going to be an appraisal. However, if you were to go all the way to trial, take this thing all the way to the end of the road, there would of course be a few more expert related fees, because you would have to pay your expert to come to court and testify. You may have to pay their expert to show up for a deposition so that we can be fully prepared for trial. So there's those other elements that might come into play. But I think the way that I explain this to folks that can give them some peace of mind is there's no cost that we would incur on your behalf that you would not have pre-approved and the justification for that cost would have been explained. We would have had a conversation where you knew what you were spending, why you were spending it, and had agreed to do so. So I think that's kind of the general rundown on how we get paid. If there aren't any other questions, so thank you for that question. That's a very good question. If there aren't any other questions, then I think I will go ahead and wrap up for today. We wanted to keep it to 45 minutes at a max, so we're about right there. And if anybody, I'll just reiterate, if anybody needs to or desires to give us a call, shoot me an email, either one, we'd be happy to have some more conversations with folks and go from there. So thank you for coming. Hopefully we'll hear from you folks, and enjoy the rest of your day. Thanks.